create leaders and not followers. Access must be created where it is possible, and there are small things each of us can do. At LawSikho, at Project Maverick, our aim is providing free training for law aspirant for all law entrance examination. In this endeavor of our, we have been running these live interactive session for include especially towards the syllabus which is asked in common law admission test and other law entrance examination. Today, I'm very happy that we have with us Mr. Lalit Ajmani. He's a senior of mine. He is an alumnus of NLU Punjab, and he's practicing advocate at Delhi High Court. And I remember I have a memory of him being being a mentor to me when I was doing my first moot NLIU Juris Corp. From then, I've known him to be having this academic bent of mine, and his the last few sessions which he has taken online have received tremendous response. He has agreed to take a session for Project Maverick on the topic of family laws. Why family law? Because it's very important for law entrance examination. Depend in this lockdown period when the cases of domestic violence are rising, and also we have seen in previous law entrance examination questions or Hindu Marriage Act, especially on who is Hindu, what is Section 13, which deals with divorce, and also with respect to Muslim law when it comes down to the talaq. So, over to you, sir, from here on.
Thank you, Harsh, for the kind introduction. As Mr. Harsh has already briefed us regarding what this session is going to be, I just give you the brief of the whole session and the compartmentalization, and thereafter we can go ahead with the topic by topic. So in marriage laws, it is not just one or couple of topics which revolve or which constitute the spine of marriage laws. In fact, there are so many issues. For example, divorce, maintenance, dowry, custody, nowadays live-in relationships, and so on and so forth. So I first we start with the divorce. Thereafter we come down to maintenance. Thereafter we'll also talk about dowry and domestic violence, and thereafter we'll come down to the new issues like live-in relationship or the violence, especially during this COVID times when the courts are practically not working as such. So what are the remedies at this point of time, what a person should do, what a person should not do? And at the same point of time, I must also clarify that I'll be keep dealing and I'll be keep touching with all the important nuances of law and the important sections through which students, be it law students or the students who are preparing for law examination, they can get some benefit or help through these sections. And lastly, we'll also be discussing about a couple of judgments also, which are really important in almost every part of this marriage family law. And then if any of you have any questions regarding this, we would be more than happy to take it up. So to begin with, I would like to begin with the divorce law. So in Hindu Marriage Act, there are two types of divorces. First is contested divorce and second is mutual divorce. So first type of divorce is a contested divorce. It means that where only one party wants to divorce, whereas the other party does not want to divorce. It generally takes years to get settled because in divorce proceedings, generally one proceedings begin and it opens the way of the other proceeding because there are so many counter proceedings. Once you start divorce proceedings, the other party may get irritated. He or she will file some other allegation against you, and this circle keeps going on. And what our judiciary, Indian judiciary, tries to do in all family matters, not only just divorce matters, they always try to settle the matter irrespective of the fact whether the case is new or whether the case is 10-year-old or 5-year-old. So in contested divorce generally it takes time, but as we just discussed that the endeavor of the court is to settle the matter. And from my own personal experience, I can say that whenever you are referred with any family law, always keep the door open for the settlement, because today or tomorrow your client is going to settle the matter in one way or the other. Even if the person gets the divorce, he or she eventually has to settle with certain terms which the honorable court may decide. So the most of the cases, the basic gist is the negotiation and the settlement. So from the beginning, you must be very clear that you should open the door for negotiation in all such cases. So having said so, Section 13 of Hindu Marriage Act is the concerned section which deals with divorce. There are various grounds of divorce. Some of the common issues are cruelty. Cruelty is something which I think cannot be defined with any particular judge, with any particular set of words. Or if I take even the 100 judgments, there would be something else which can go beyond the ambit of those 100 judgments. But the basic gist of cruelty is that the one party is inflicting injury upon the other, be it on emotional side, be it on physical side, be it on psychological side. Especially now, if considering this COVID times, a lot of issues regarding the domestic violence have coming up. So it's not necessary that the physical violence is going on, but it's equally important to understand that the person may be feeling, or either wife or the husband may be suffering on emotional or economical or on mental basis. So all these things make the ground of cruelty. It is the foremost form, and I would say that most common issue of divorce is the cruelty. Then we also see that the desertion in Hindu Marriage Act, it is seen that at least 2 years of desertion is necessary. For example, if your husband or wife has left you and he or she has not joined you for at least 2 years, so you can go and ask for the divorce and stating that on the basis of desertion, that the other party has deserted your company without any reason or without any good reason for more than 2 years. So for without any reason, in the sense that you should not come up with bad hands, meaning thereby that your conduct should be clean, your conduct should be in consonance with the matrimonial obligations, and of course you should not breach the sanctity of the marriage. So if that's not so, and despite of that, if the other party has left the company for more than 2 years, then of course it's a good ground for divorce. Thereafter, there is another issue of medical, I would say, unfitness. It could be impotency, or it could be some disease which is incurable. Now, when it comes to medical issues, it has to be seen that whether the said issue was going on prior to marriage, whether this particular disease is incurable, or whether the particular disease can be cured within a given point of time. So all these things need to be considered to determine whether the medical issue will form the ground for divorce or not. Thereafter, there are so many other grounds. Uh, there is one other ground, that if the other party has not been heard for at least 7 years or more than 7 years, so the aggrieved party can go to the family court and ask that the other party has not been heard by any of the concerned members, be it family members, be it friends, be it the related members who are related either in physical proximity or by by the friendly relationship proximity. So if the other person is not being heard for more than 7 years, that's very rare. But in one or couple of instances, it has been seen that when the party has when the party has pledged to some other country, and the aggrieved party has not even heard of, and the party who has left the company and who has not been heard of more than 7 years, he due to one way or the other, he is keeping himself away from the company of the other. So of course this will attract desertion also, but desertion, you have to show that the other party, you can still have access to the other party, but the other party has deliberately left the company of yours. Whereas in your 7 years issue, the only point you need to prove is that despite due diligence, you are not able to contact, or you have no access to the other party. So these seemingly two similar issues, but there's quite difference between these two minimal grounds. So these three or four things are the main issues when it comes to contested divorce. So now in contested divorce, there is one important application under section 24 of Hindu Marriage Act, that is the maintenance application. It states that during the pendency of the litigation, if one party is unable to sustain herself or himself, he can file for the interim maintenance, and then the court may decide by seeing the economic needs as well as wants and the capacity to earn of both the parties, and then the court direct the other party that during the pendency of the litigation, the spouse can be directed to pay a certain amount of money to the claimant, or as well as to the children also. But what is special in section 24 is that it is gender neutral. We will talk about maintenance in the coming part of this session, but we will see that in maintenance almost every ground is provided for women, but in section 24 it is gender neutral. Even a man who is unable to sustain himself and at the same point of time, if his wife is earning well, so he can go and approach the court for asking interim maintenance. So this is a very welcome step, and I personally feel that this general neutral maintenance law should be provided or should be incorporated in other aspects of law also, so that people, especially the guys who are not earning well, they could also go ahead and claim their maintenance from the other party. You might not agree or disagree, because during college time, I was also under the apprehension that probably only the women are unable to maintain themselves, and probably men are always having sufficient means to maintain themselves, uh, despite of the fact whether they are intentionally not maintaining themselves or not. But in practical scenarios, when you go and when you observe the things, you would understand that yes, there are certain scenarios where men, despite their efforts, they are unable to maintain themselves. So in all those scenarios, this section comes very handy for those people. Now coming to the second point of divorce, that is a mutual divorce. Now in mutual divorce, the difference is that in this case, both the parties want and they are ready to get the divorce. The essential thing is that both the parties must be living separately for at least 1 year. Now, living separately does not mean that they should be living separately physically, but living separately means that they should not be living as husband and wife together. So they can be living under the same roof, but they can also be living separately because they are not dealing, or they are not maintaining the relation of husband and wife, which they in normal circumstances used to follow. So this is one of the essential which they need to follow. And on these lines, we also need to understand that not only on the day one they will get the mutual divorce decree, they have to follow the two decrees to get the mutual divorce. It is called the first motion and second motion. On the day one, when the parties will present their case for mutual divorce, the court will see the facts. If everything is settled, then the family court will give the first motion. First motion in the sense that yes, the court has agreed to the fact, and the first part of mutual divorce mechanism has been followed. Thereafter, 6 month cooling period is provided to the other parties, stating that for at least 6 months following from the date of first motion, parties cannot file for the second motion. And after 6 months, but prior to 18 months from the date of first motion, parties are required to file for the second motion. Otherwise, their first motion will be cancelled. Now, after this cooling off period, if the parties file for the second motion, and court will see that yes, parties are unable to reconcile or unable to settle their differences, the court will then issue the decree of mutual divorce. So it's a two-way procedure which the parties need to follow. However, there are certain scenarios where the 6 month cooling period can be curtailed. But prior to that, let's understand why the 6 month period is given. Now, the legislation under section 13B has stated that the 6 month period is given, and in various judgments, it has been explained that the 6 month period is given to the party so that uh, they can review their issues. And if they think that they have made a mistake of going ahead with the divorce, so they can undo that mistake and they can settle the matter. So of course it's very important that a certain amount of time should be given to the party so that they could actually settle, because saying that the parties will go and settle for the divorce is one thing, but actually going to the court and getting the divorce is entirely a different thing. Because even in India, irrespective of the fact whether in which society you are a part of, whether you are a part of the metropolitan society or whether you are a part of not so metropolitan society, divorce is still not welcome in most of the parts. So that is one of the reasons that why the 6 month cooling off period is provided. But in the case of Amarjeet Supreme Court judgment, the Honorable Supreme Court had stated certain guidelines to the family courts. In while following those guidelines and in certain scenarios, the family court can curtail down the period of 6 months to at least 1 week, and parties do not have to wait for 6 months in those circumstances, and they can get the second divorce within a period of, I would say, 1 month or a couple of months. That's it. So it's a welcome step, and it's a very widely welcome judgment by all the concerned stakeholders and of course the litigants. So the scenario should be that the parties must be living separately at least from 18 months prior to the filing of the first motion. Meaning thereby, suppose if the parties have filed for first motion on 1st of January 2020, so they must be living separately as husband and wife at least 18 months prior to 1st of January 2020. But in the normal scenario, for merely for filing the first motion decree, they must be living separately for 1 year, as we have already discussed. So this one thing is needs to be considered. The second issue, the second guideline which the Honorable Supreme Court has stated, that the court should be convinced that yes, there is no ground and there is no possibility that the parties could come together and settle the differences. It depends upon facts to facts, and during the first motion, generally family courts ask the parties, not only just the lawyers but also the parties, whether there is any settlement or whether there is any possibility of getting the parties back onto the track and undo the process of divorce. So and apart from that, it also needs to be seen whether the whole mechanism is being followed by both the parties without any coercion or fraud or not. So these four things need to be considered in every scenario when the parties come to the family court for the dilution of the 6 month cooling off period. So in practicality, what happens in possibly every case, parties go to the court and ask for this cooling off period. And in few cases, of course, cooling off period have been waived off, and in few cases, court are quite reluctant to waive off the cooling off period. But after 6 month period, parties are free, and there is no legal, infirmity or legal roadblock that could tether themselves to get this divorce decree. Now, apart from this mutual consent decree, there has to be one settlement agreement also. Now, in while filing your divorce petition, both the parties must settle their all differences and all their finances. For example, if the parties, husband and HNW, they are blessed with one baby girl. So in the settlement agreement, it must be written that who will be having the custody of that baby girl, and apart from that, whether the husband has given any amount to the wife or not. And it must be clarified that if there is any amount, the amount should be written. In general scenarios, the cash and the check are not followed. Only the DD or any payment through electronic mode is agreed, because in check it could be the issue of bouncing of check or dishonor of check. So the court do not accept checks there. And in cash scenarios, of course, it's not going to be a penny amount. It has to be something good, because for parties are getting settled and parties are getting diverted for their entire lives. So the minimum amount cannot be less than anything in 6 figures. So generally 6 figures, 7 figures, or even sometimes the 8 figures settlement depends upon the status of the parties and of course their needs and wants. So these for these, the cash is also not agreed. So only the DD, and the second part is the electronic mode. These two modes are agreed. So all these things should be written down. In addition to that, if there is any litigation pending between the parties, the parties must write down the details of that litigation, and they must also state down whether the parties have agreed to settle the disputes. Yes, of course, that's why they are getting divorced. The second part is that when are they going to take back the proceeding? For example, if the wife has filed the divorce, has filed the dowry decree, whereas on the other hand, after a point of time, they agreed for the mutual divorce. So it must be written that the wife shall withdraw her divorce case either prior to the first motion, or must be prior to the second motion. So that depends upon the facts, circumstances, consent, and the trust of the parties, of course. Because at times, what is seen that the other part, especially one of the spouses, comes and says that yes, he or she wants to settle the matter, and once they get the first motion, they show their true colors and say that it is only to irritate them and to harass them. That's why they go ahead with the first motion thing. So in considering all these issues, the settlement agreement must be drawn upon, and it is of course the duty of the Honorable Family Court to consider and to see whether all those ingredients have been followed or not. So these are the few basic things that every divorce and every mutual divorce decree must witness and must be proceeded further. There is one important thing in contested divorce is that parties must be married at least for 1 year, so that in order to get the divorce. For example, in contested divorce, if the marriage happened on 1st of January 2020, so if any of the party wants to get divorced, so he or she needs to wait for the entire 2020, and only in 2021 he or she can apply for the divorce. And if you see that so is the case with the mutual divorce, because the parties must be living separately for at least 1 year. So in both the scenarios, I can say that the parties must be at least 1 year old as husband and wife, and only after that they could ponder upon the possibilities of divorce, whether it's a mutual divorce or whether it's a contested divorce. However, there is one point, and I can say that in law there is remedy for almost everything. So suppose if you feel that if you are being cheated, or if there is an arranged marriage and there is some fraud played by you, that the other party's parents come up and say that his son his earns a lot, or works in XYZ company, but after the marriage you get to know that everything was sham and everything was just fraud and misrepresentation. So do you need to wait for 1 year in those scenarios? No. Then section 12 comes into picture. Section 12 of Marriage Act, it states that if there is a fraud and the fraud goes to the sanctity or the fundamentals of the marriage, then the parties can go and file their petition for void of marriage, for declaring the marriage as void and null, meaning thereby that the court will issue the decree stating that this marriage has never have does not have any sanctity in law, and the parties after the decree will not be termed as husband and wife, and they can be parted away. So this is extraordinary remedy, and generally this can be dealt only during this special 1 year period. So there are so many cases. In my own personal experience, I have witnessed one or couple of issues where the parties have just married, and after 3 or 4 months they get to know that their spouse have cheated in one way or the other, and that goes to the sanctity of the marriage. So these three things, I would say, goes or cover almost everything regarding divorce. So we have discussed mutual divorce, contested divorce, and of course the fraud, even when the parties are not 1 year old as husband and wife. Now I think it's a good time to move to the second topic, and the second topic is the maintenance. Now we have discussed in the divorce point about the section 24 application, and as we discussed that it's a general neutral application where either of the parties can ask for the maintenance. Now when your client, or when if you are an aggrieved party, if you think that you don't want to get divorced, but at the same point of time you want your husband to pay certain amount of money to you so that you can sustain your life, and if you have the custody of your child or children, then husband of course has more duty to pay towards the children also. So if you don't want to get divorced, so you can easily go and file section 125 CRPC application. This is of course, this is once again a secular law. As we discussed during the Hindu Marriage Act, only the Hindus and Sikhs who are covered under the Hindu Marriage Act, they can only get the facility of section 13, 12 and 13B. Whereas in section 125 of CRPC, even non-Hindus, for example, Muslims and other religions who do not fall under the ambit of the definition of Hindu, as explained in the Hindu Marriage Act, those people can also come and file the maintenance issue before the concerned court. Now, here the concerned court will be the concerned magistrate. If you if you want to file it before in a metropolitan magistrate, it would be a metropolitan magistrate MM, or if it's a non-metropolitan city, it would be a JM. So this is one of the benefits of section 125, that even the non-Hindus can go and ask for the maintenance. And not only just the wife can go and ask for their maintenance, even the children and even the old age parents can avail the benefit of section 125. And one more important thing about section 125 is that during the pendency of the case also you can get the interim compensation. So suppose it takes, for example, it takes 2 or 3 years to get this 125 decree, but in the meantime, of course, you might not have sufficient funds to pay fees to your lawyer or to go through this all litigation ordeal. So court in those scenarios can ask the husband to pay interim compensation to you on monthly basis, and after the judgment the court can calculate and can consider all that interim compensation while awarding the final case. So this is very helpful, especially in the case where the parties don't want to go and don't want to press for their divorce. Thereafter, there are two to three more maintenance clauses. The other is section 23 of Domestic Violence Act. There is a Domestic Violence Act. Once again, it is also a gender neutral, meaning thereby that a girl of any religion, be it Hindu, Muslim, Sikh, Christian, whatever, he or she can file an application under section 23. We'll discuss this application and this BEAR Act in the coming session, in the coming part of the session, that is the domestic violence. So not only just section 12 application can be filed, you can easily file a section 23 application. It is also an interim measure which can court provide, that during the pendency of the litigation, the either of the parties can go and file the application. But one point that we need to consider in all this thing, that there has to be some domestic violence, only then this petition is this point is maintainable. Whereas in section 125 you can say that yes, it's your right to get maintenance from your husband, whereas in Domestic Violence Act you have to prove that you are not getting payment, or you are sustaining some kind of violence, be it physical or emotional, economical, or as the case may be. And apart from that, yes, there is one provision of section 498A, dowry. We'll just discuss in a while. So these 3 or 4 points, four topics, and I would say 4 clauses of maintenance are that: first, section 125 CRPC; second, section 24 of Hindu Marriage Act, if the divorce proceedings are going on; third is section 23 of Domestic Violence Act; and the fourth is section 498A of IPC. Now I am coming to this point of section 498 of dowry. Now, in general scenario, dowry is often considered as, only when the party commits suicide, or when the party has done something, only then the maintainer or only then the wife can go ahead and file this 498A complaint. It is not the case. Of course, that there are the dowry death case which are duly covered under this section, that is 498A. But at the same point of time, the wife can lodge a complaint not only against the husband but also against her in-laws. So this is something which is not available in your divorce, and which is not available under section 125 also. But this is something that gives benefit to the wife, that she can file a case against the husband as well as her in-laws. And not only just 498A, there could be so many other ingredients which she can file. For example, if she thinks that there is a breach of trust, she can file for, she can impede, she can bring that section. If there is physical violence, she can allege, or she can put all those relevant sections in the concerned complaint. Now the procedure in dowry cases is different from other cases, because it's a entirely criminal case. So first you need to file an application before the CAW cell of the concerned police station where you are residing. So after, when the CAW cell receives your complaint, then there is one or a couple of rounds of settlement, which the CAW cell endeavors, so that the parties can come together and settle the matter. And once the CAW cell thinks there is no point of settlement, and the other person is actually creating a lot of issues and hurting the wife, thereafter the FIR gets registered. And once the FIR gets registered, only thereafter police will investigate the matter, and after the completion of the investigation, the charge sheet will be filed, and charge sheet along with the FIR will be filed and will be presented before the concerned court. And court, after taking cognizance of that charge sheet, will summon the husband and in-laws, as the case may be, and thereafter the whole litigation process begins. Now there is one point which parties usually use, and some of the wise misuse of 498 is that once the FIR gets registered, none of the parties can withdraw it without the due permission of the High Court. Meaning thereby, suppose if you file a maintenance application, maintenance case, if you file divorce case, or if you file domestic violence case, you can easily withdraw it, and you don't need the consent of the High Court or the concerned magistrate. But once the FIR under 498 is filed, even the wife cannot withdraw it. She needs to take permission from the Honorable High Court, and only the High Court can quash or set aside the FIR. So that's why that in few scenarios it is being witnessed that 498 is grossly misused only to serve one way or the other, if not the ulterior motives, I can say. So this is very important to consider. And one way to get, if there is innocent husband, or if there are innocent in-laws against whom this frivolous litigation is filed, so there is one point to get themselves away and to get themselves free from all this litigation, is to file the quashing petition before the concerned High Court under section 482 of CRPC. Now that gives a lot wide powers to the High Court, and High Court, without even prior to the beginning of the entire criminal process, the High Court can quash away the FIR against the husband or against the in-laws, as the case may be. So this is one of the extraordinary remedies which is available to husband and to in-laws. But generally, the settled law is that the High Court should be very sparing and very cautious while quashing all those FIRs, because at that particular point of time, nobody can say that whether this is a frivolous case or not, because for that the appreciation of witnesses and evidence and the entire process of trial needs to be followed up. So but if there is apparent from the face of record that yes, there is something malified and parties are being arrayed unnecessarily, then of course High Court can come into picture and quash the entire FIR against the concerned person. Now, moving ahead with the domestic violence. Domestic violence is something which has been going on from years and years, and especially very sadly to note, as Mr. Hirsch, you have pointed out, that during COVID, that domestic violence cases have raised to enormous level. And considering the fact that the courts are not functioning, so a lot of people are also under this apprehension that when the court will start functioning, only then they can go ahead and file this case. But there are certain ways through which this issue can be settled. First, we understand what is domestic violence and how and where the parties can resort to. There is a Domestic Violence Act 2002, that is Protection of Women from Domestic Violence Act. It is a specific legislation which was enacted by the legislature, keeping in mind the astonishing rate of domestic violence. And what's important in this Domestic Violence Act is that no religion is being left out. As we discussed that in Hindu Marriage Act, only the Hindus who by definition come under the Hindus only, they can get the benefit of Hindu marriage laws. But in Domestic Violence Act, any party of any religion can come and file the case for domestic violence. So there are certain important parts which we need to consider, that once you file a domestic violence case, there are certain remedies which you can ask for. First, you can ask for a permanent for the residence in the matrimonial house first. Second, if you think, or if the factual matrix demands that a wife cannot reside in the matrimonial house, or if the husband or if the in-laws are not ready, or if the husband has transferred to somewhere else, and he was residing on a rental accommodation, and now he is not paying anything, and at the same point of time he is not agreeing to take his wife along with him. So in such scenarios, the wife can also ask for the separate, almost equal accommodation, even during the pendency of the case, and of course after the pendency of the case also. So this is one of the I would say watershed provisions of law which has dealt with the practical issues, because as we all know that people do not welcome the married lady, especially when there is dispute going on, and sometimes it is also not very viable, especially on economic terms, for the wife's parents to take care of the needs of the wife. And when the wife is carrying especially when the wife is having the custody of one child or more than one child, then it is of course very difficult for the wife's parents to handle those things. So in considering all these scenarios, these provisions have been incorporated in this Domestic Violence Act. Now the process of the Domestic Violence Act is that you file a Section 12 application. Under Section 12, you mention what are the issues that you want. Not only the interim compensation, you can ask for the I would say the lump sum compensation at the end of the case. For example, that due to this injury or due to this horrendous ordeals of events, you are entitled for XYZ amount. So court, after perusing the entire case and the trial, can come to the conclusion, yes, the wife has has proved that yes, she has been a victim of domestic violence and she is entitled for such and such amount. This happens only at the end of the case. That depends upon what are the status of the parties and what is the nature and what is the gravity of the violence that the wife is able to prove. And it is very important to file in Section 12 application. The drafting comes more important than anything else, because you can still have a chance to to appreciate evidence in one way or the other, to cross-examine the witness. You can still file some application for re-examination of witnesses. There are so many things, and it is not only just one day event. But when it comes to drafting, I think that's the most important thing. And sometimes people, especially the wives in such scenarios, they don't pay heed to this scenario, because they think that only after the filing of the case they will get the justice. But what is important to note is that the court will revolve around, and the case will always be based upon what is being written in the Section 12 complaint. Of course, the reply is also important, but not more important than what you have written in Section 12 petition. And not only in just Section 12 case, in your contested divorce also, in your Section 125 maintenance also, and in your complaint also. So make sure, if you are currently watching this, and if you are considering to go ahead with any of these remedies, make sure that your drafting comes first into picture, because if your drafting is good, then probably everything can be settled, because the court has to rely upon the complaint or the petition, whatever the person has submitted to the court. And having said so, there is one another, I would say, legal procedure which courts usually follow. That once you file a complaint, court will see if the court prima facie thinks, then the court will appoint a particular officer, that is the protectioner officer, and protectioner officer is required to file a report based upon the complaint that the wife has filed under section 12. And after perusing the report and section 12 application, if the court thinks yes, there is a sufficient ground to entertain this application, only thereafter the court will summon the husband for in this case. Now, in this case also, not only just husband can be arraigned, you can also file a case against your in-laws if your in-laws have also contributed to this to your issue. But one more issue, one more point in these scenarios, that if your in-laws are not living in your matrimonial house, and if you think that it would be better or it would be convenient for your case if you array your in-laws, so that you could put pressure upon the husband, and they can come together and they can come on the settlement terms, and you can get whatever you are looking for. But court in so many cases have clarified that if the in-laws are not living in the matrimonial house, along with the husband and wife, then in almost every scenarios, in-laws are entitled for being for being sidelined from this case, and they can easily be shielded away from this section 12 application. So wife, when you are filing case, something that you need to consider. Of course, there could be one or couple of instances where the point a point that the in-laws have actually contributed to the violence can be proved, but it's very rare and it depends upon facts to facts. But in general scenario, physical proximity is something which comes to the defense of the in-laws. Now, I think that 4 points we have discussed so far, that is divorce, maintenance, dowry, and violence. And I would say that couple of three more issues I would just briefly sum up them. And those are custody, live-in relationship, and the defamation. The custody, yes, that for example, if the concerned wife and husband have left with one or couple of child, and they are just concerned with the custody of the child, they are not concerned with anything else, so they can easily file a concerned application before the concerned court, asking for the custody. It's available in the Hindu laws as well as it's of course available for the other non-Hindus also. But that depends upon facts to facts first, because the age of child is very important. In most of the scenario, if the child is up to 5 years, the first right is of mother only. But in certain scenarios, that could be relaxed, depends upon facts to facts. And in the suppose if the cases are going on, if the litigation is pending, be it maintenance, be it divorce, or be it dowry, or I would say if all these 3 or 4 litigations are pending, you can still file for application for the custody. If the divorce proceedings are going on, you can file a application in the concerned law asking for the custody. And if the maintenance is going on, of course you cannot file, because that is strictly for the maintenance. You have to file the other case. Dowry is something that again does not give you any right or any room for asking custody. And domestic violence is something that, of course, prima facie and legally speaking, you have to file some other application for custody. But especially in divorce and domestic violence, courts, as we in the beginning we discussed, that the courts always try to settle the matter. So in almost every proceedings, court will inquire about not only the technicalities of the legal provisions, but also the factual details. So court will definitely ask, and they will keep asking you that who has the custody, whether whether the terms have been followed up or not. So these two proceedings are something where you can at least try your luck and get the concerned court into motion, and you could persuade. Of course, that's only on practical terms. For that, you need to file, for legally speaking, you have to file a separate application for custody. And as we discussed, if you are mutually getting divorced, so you must specifically write it down, the custody rights, as to who have the custody. And at the same point of time, you must also write down if there is any visitation rights. Visitation right in the sense that suppose if there is one child and child is in the custody of husband. So at the same point of time, the wife also wants to visit her child. So so in the settlement agreement, it must be clearly stated down that for example, that parties have settled that on monthly basis wife can come and see her child for a day, or a child can be can stay with his mom for 1 day or couple of days. So whatever the case may be, these rights should be written down in the settlement agreement or in the custody application also. So if my suggestion is that if you are looking for custody, you in the application you come up with the idea of visitation rights, so that it would be better for the child. And of course it would make more sense for the court to entertain your application, because you are also considering the need of the child, and you are also not diluting the rights of your spouse, despite of the disputes that are going on between you. So now coming to the point of defamation, and then we'll come to the live-in relationship. So defamation, I think that there are two types of defamation. There is civil defamation and criminal defamation. In husband and wife, sometimes it's difficult to prove it, but there are so many scenarios, especially when parties are unable to control themselves and they say something or the other in the general public, or when the other party says specifically defamatory with a particular intention in the public domain. So this is something that and what needs to be considered, that for criminal defamation the time limit is 3 years from the date of cause of action. And if the party sees that due to defamation he or she suffers a lot, for example, if the other party comes to the office of his or her spouse and says something derogatory and defamatory in front of his or her clients, and he or she has lost some business or something else, and that quite happens, out due to some temperamental differences and the issues which are going on, people are unable to control themselves, and they sometimes end up doing all these things. So the agree party at that point of time can file the civil defamation. It would be a whole altogether a different civil case. It may take another 3-4 years to get the entire portion. So in civil defamation, you ask for the compensation. There has to, if you ask for 10 lakh, 20 lakh, whatever, what you think your goodwill has suffered, you need to ask regarding that. And why I mentioned the particular amount, because the particular amount will determine the amount of court fee that you need to pay. Because in criminal cases you don't need to pay a lot as a court fee. There is very fixed court fee that is very minimal. You don't even need to worry about that. But in civil cases, sometimes parties get very concerned about the court fees also, because if you ask for suppose 1 crore compensation, so 1 crore compensation will automatically bring something heavy in terms of court fee. So you have to file a civil case along with the court fee. So this is something you need to follow. And the limitation period for civil defamation is just 1 year. So this is one difference of civil defamation and criminal defamation. And sometimes it is seen that the wife and husband, they end up defaming other in one way or the other, intentionally or unintentionally. So this is something that you can also consider at the time of having such dispute. Now, in the end, we can discuss about the last topic of today's discussion, that is live-in relationship. So from the past few years, I think that the Indian society is coming up and welcoming the live-in relationship. And at times it is seeing that both the parties promise a lot of things regarding the future, but due to one way or the other, either party has lost interest or lost faith upon the other party, and he or she moves ahead. So sometimes in such scenarios, especially the girls have come up and asked for the maintenance, and the courts have very I would say very openly decided this point of fact, that if the live-in relationship partners are living together in a society, that they are perceived as husband and wife by the society at large. So yes, in all those scenarios, the concerned persons have the concerned rights as husband and wife, whatever they may cherish after the marriage. So this is a welcome step, and it is not one judgment or two judgment. It has been usually followed by so many judgments. So if a party is living in a is having a living relationship, and if the neighbors or if the society of their or if their friends and relatives consider or perceive themselves as replica of husband and wife only, or as a replica of this that relation, of course they consider, or they at least fall in the realm of the family laws as husband and wife, and both of them have obligation against each other, and of course they cherish the benefits whatever they may have in the law as the wife or the husband have. So I think, Harsh, we have discussed almost all the important issues regarding that. And before I hand it over to you, one important development I just missed to point it out. It has just come upon 30th of June 2020. It's a Delhi High Court case of Deepthi Kumar. It has dealt with the issue of illegal tape recording of your spouse. So in that case, what happened that the husband has recorded something, some conversation of her wife when her wife was talking to her friend, and the wife consent was not there. So this issue came up before the honorable court in this case, and the court needed to decide whether the evidence is good enough to be proceeded further or not. So in this case, the court has stated yes, there is no doubt that the right to privacy has been infringed, but at the same point of time, it cannot be considered, or it cannot be denied merely on the basis that the evidence is being gathered only by illegal means. So even this kind of evidence is appreciated, depends upon the facts and circumstances. But merely because the evidence is procured by illegal means does not mean that the particular evidence cannot be considered in a court of law. So this is something that will definitely that will definitely derive various parties, because Hush, or I can easily say that if I meet 10 matrimonial litigations, at least in 7 litigations, one party or the other party asks me or uh, shows some interest to get some evidence, even by illegal manner. So this law is something I would say that may push parties to get the evidence by one way or the other. But as we have discussed, that it is not necessary that they will be admissible. But yes, it is for sure that merely on the basis of illegal procurement, it cannot be denied or discarded by the court.
Yes, sir. Thank you so much, sir, for taking out time for this session. And before I close this session, which is titled Family Laws, there are a few things which I believe you must know. And sir, you may correct me if I'm wrong. Family law matters are dealt under concurrent list mentioned in 7th schedule of the Indian Constitution.
Correct.
This is important. Secondly, you must write down in your notebook or wherever you are, even if in your hand, Hindu marriage is a sacrament and Muslim marriage is a contract. A very, very important lines if you're preparing for any law entrance examination. This being said, also in our next sessions on family law, we will be discussing who is Hindu, because this question comes down to the picture when on 5th of August we are having this Ram Mandir Pujan, and Prime Minister Modi ji in his individual capacity is attending it. And then the question marks are being raised on who is an Hindu. That being said, sir has already taken us through section 13, which is very, very important for law entrance examination. That is divorce. That being said, under Hindu marriage, these things, along with that, there are some other terms which you must know, and we will bring this forward in another session. Uterine blood, that is important term. We'll introduce you to this term. Sapinda relationship, again, Kha Panchayat also. And also we will go down to Muslim law to an extent to understand how it is a contract, what is meher, and other terms, what is qabul ul, etc., etc., and what is this talaq, types of talaq. On this note, and giving a reminder again that Hindu marriage is a sacrament and Muslim marriage is a contract. See you tomorrow in another session, 4 to 5. Thank you so much, sir, for taking out time from your busy schedule.
Thank you, Harsh. Thank you, all the people who are there. Thank you so much.